So one of the things that we thought we hadn't really covered was the question of gender. While we spoke about rights of the child, while we spoke about freedom, liberty, we spoke about other issues. We haven't really touched upon the issue of how does gender or gender-based discrimination intersect with the question of dignity. So we thought we will spend some time, and also the session was also speaking to this question, particularly in criminal law. We find that with reference to crimes against women, and of course that's also some of the topics that you have picked up. It is so many that we are trying to look at here, right? So one of the topics that you have picked up is the question of the child bar media, which also has the gender dimension in two ways. I think one is a case study that was picked up with reference to particular persons become targets for media trial. And this can happen in two ways. One is like in the case of what you have picked up, which is a Riya Chakrabarti case. It is about the identification of a particular person and literally hounding her and running a trial with absolutely no material. It just became very sensational. It became something that everybody is becoming. So the way in which gender worked in that case was the person who was associated with the fact, it's not anything with the horrible incident, it's not even a crime, but the fact that she happened to be of the star, happened to be associated with the person, I don't know if it has full context of this. I've heard. Yeah. So it was just by association that she got targeted in a particular way. The gender is playing out in that case by finding people who are easy targets or finding people who somehow everybody else seems to have a bigger, what we should only call a voyeuristic interest in watching. I am being clear. So that's like one level in which the whole gender dynamic works out. But the other thing, which is what Dr. Murli had in mind, or we had in mind when we initially designed it, was also to look at the business of, and something that came up yesterday as well as in the conference, that among all crimes against women and this are seen in particular ways, even within prisons. That is, even within a community that has been convicted or is accused of crime, there is a hierarchy of particular kinds of crimes. And we find that in the media as well. I mean, very clearly, at least in the early big cases that we've seen in the past 5 years, the kind of media attention that was focused on two trials. One was a trial, not even a trial, it was a trial in Hyderabad of a doctor being accused of a doctor who was subject to horrible violence and was killed. There were 4 young men who were rounded up and they were killed in a negative account. So there was not even a question of a trial, question of presenting them. There was no media. There was a media trial. There was unanimous consensus that yes, these people who are guilty, they were found in that place. There was allegedly some evidence that was available against them, and they were declared by the media to be guilty. And so the people who committed the encounter or who carried out the encounter were in fact vandalized by. But that's in more than the Disha case in terms of a media trial. What we saw here in Hyderabad was a clear media trial where the verdict was out even before the charge sheet was filed. So we were looking at in the context of criminal law, this is one dimension of particular kinds of crimes which receive that kind of attention, which builds kind of pressure on all institutions to respond quickly and immediately. That's the case where you have media personalities put out a call for yes, this person should be act to that. I mean, the punishment was given even before charge sheet was filed or there was any evidence. Because the punishment was something that the people were very interested in Hyderabad, yes. So then you had personalities, you had very reputed journalists. I mean, so it was not even what you would ordinarily call, travel houses, people who want to grab a midland, who want to stay in that. It was like seasoned, reputed journalists who jumped into the because they felt that this was something which kind of shocked everyone. It was a very shocking incident. But that's where the question of how can we negotiate with the way in which particular issues are portrayed in the media. And what is the responsibility of the government for something? Where does the dignity question play out, and how can we then think of a dignity question? And then a complete consensus on all crimes that's the only way in which that particular those instance can actually be portrayed and crime reported. So this is the other dimension that we're looking at in terms of how does gender play out and how difficult it is for you to raise a dignity question when there seems to be this broad-based consensus in society with reference to particular crimes. And so anybody associated with that will automatically start with that brush and the punishment is given even before anything. So this is one. But the other, so if you read the case law that we have given you, just to readings with you, please take a look at the two cases that we have listed there. So I'm sorry, the housekeeping question. All of you have signed the sheet for today?
No, they didn't. I have
So can you please? You have a list of cases? Anyone take a look at the reading list? We've listed some material for the discussion in class today. Can you read about what the two cases?
For this lecture, was chiefly for the South Africa Human Rights Commission and another.
And
And Babe and others versus Russia.
so are you able to find any read up on what these two cases were? I think each of these cases also has this short summary, very small write-up about what the cases, what the issues in these cases were. So if you could take a quick look and tell me what they were.
Somebody against hostel. It's regards to protecting LGBT community. There, Section 10 of the Equality Act was found unconstitutional in next step that the inclusion of the term that
Inclusion of the
ultimately the court reasoned that it is not possible to protect the rights of LGBT community without prohibiting hate speech.
So this is the case of a broadcaster who very deliberately, intentionally engaged in hate speech against the LGBT community. And the question was, and he claimed it to be a part of free speech. That I have a right to say and voice my opinion. I have a right to say things that people may not like. And how can you say that I always want to be respectful of things that I deeply disagree? Now, in the context of hate speech, there is this long history of certain jurisdictions which have believed that the only way in which you can address hate speech is by more speech. That if there's a person who's saying something horrible, then the only way to counter that, after all, it is speech. At the end of the day, it's only speech, it's only words. You ought not to take it to any other, what should I say, that, that what stays at the level of words can only be addressed at the level of words, because that's the jurisprudence that's current to the United States. Whereas in India, we all know that public order and series of restrictions which are possible on free speech. Right? Enmity with friendly countries, friendly relations with neighboring countries, defamation, contempt. Right? We put all of these into the constitutional provision itself. And so there's this very strong argument that in India, free speech is not like an absolute. It is very much curtailed by all of these considerations. And we believe that there will be reasonable restrictions on speech. And these reasonable restrictions can be by criminal law as well. So we do have provisions in the IPC, right? The erstwhile IPC and the new courts as well. Which talk about a range of provisions which are prohibiting speech that has the likelihood to cause a public nuisance, speech that has the power to hurt religious sentiments, speech which can be provocative. So you have like range of penal law, which deals with the question of not just speech but potential speech as well. But we know that people can be prohibited from addressing crowds. We know that permissions can be withdrawn for events. You will need prior permission for events.
Gag orders also sometimes. Gag orders.
You have gag orders which are issued against eminent personalities who are facing particular kinds of allegations against them. So free speech question in that is quite muddy, not very clear. On occasion, we directly borrow from the United States. It says, yes, no prior restraint. And then we will have internet shutdown for 6 months, which go unchallenged. Right? Both of them are happily coexisting and really never know at any point of time where India stands on this whole business of free speech. So the question is, one, should you allow free speech to be everybody's right and claim that people should be free to say whatever they want? So there is hurtful speech when somebody else can say also think hurtful things to them and let's say this. So you don't really escalate this to any other thing. As to call it hate speech, the whole business is a lot of people are really uncomfortable with the idea of hate speech. What do you mean by hate speech? How do you define hate? I mean, in legal terms, hate is not a legal word, no? But under IPC, there's no offense called hate. You will attack an assault, whatever. There has to be a harm that is visible for you to be able to take action under. So, as hate as such, an emotion as such is not something that we want to repress. And at the same time, not a thing, religion, not an ideal society, not an ideal society in which everybody is very much in love with each other. It's not an ideal world that we are in. We do believe that there can be people who do not like each other. What is it that the Constitution, these constitutions of provisions are providing for this, assuming that we are not going to be friends with each other? What are the modes of association? How is it that we talk and interact with each other while not liking each other? Because if we all like each other, then we don't need any rule. we all getting around perfectly fine. There is no need for any group. There is no need for there is no need for a legal protection. There is no anything. So the assumption is that yeah, we're not going to like each other. So then, how does one talk about those boundaries? To say, okay, when words translate into something more? When do words translate? Is having an opinion that is hurtful to another? So if I have an opinion about anybody else, whether on the basis of race or gender, religion, whatever, I have an opinion about somebody else, which is not something that the other person will die. Does that automatically make me somebody who can come within the purview of the law? Does it automatically make my conduct something which can be censured through penal provisions? So the question is very clear, right? It's saying the question is about criminal liability. When and how do you make people criminally liable? When do words by themselves, right? All of you remember what is the standard that we use in the constitution law and 19? When can words make that bridge? It's the title of the movie. There is a danger. So you will need to make that jump between a word imminent harm. And that's why I'm asking you to pay attention to it. What is the difference between harm and harm? And do we need to make that distinction between what people would feel and again something that is very tangible in terms of harm? Not saying all harm necessarily has to be tangible. Is there a higher threshold that is required for you to be able to say that this speech needs to be shut down? Or when we use this idea of an intrinsic worth or an intrinsic idea of dignity, irrespective of the harm, with no reference to what is the harm that is caused the other. Possibly no harm has been caused the other. Okay? The person only felt that. Only felt hurt. Does that constitute enough action for us to talk about speech that needs to be prohibited? So, in the context of what we were identifying as the portrayal in media, one question is how does media portray particular things? And how do people in media portray particular things? And what possible measures are there for us to engage with this question of media portrayal? Given that the whole business of media comes very much within what is known as the freedom of speech and expression, given that you remember that very famous case of the UPSC tutorial, where you had a particular channel that was targeting people belonging to particular communities, and the matter went up to the Supreme Court. The Supreme Court was called upon to shut the channel down, and the court refused to do it, saying that if we get into this, then it would become the judiciary setting out or becoming very much party to this. We cannot do it. We can only assess whether what state has done is adequate, inadequate, reasonable, unreasonable. We can do that. But we can't dive and say that this should be shut down because that would result in far more widespread power of the judiciary to praise speech. But they don't worry about that when they give gag orders. Still, in a gag order, the Supreme Court already taking a decision that this will not be reported. So that is clearly a case where the judiciary has already committed itself to not allowing for a public discussion.
Not complete.
Even if it is no. In the good cases, it is complied. I think it was a Subhra case or was it the Sahara case in which the Supreme Court later very clear statement that no, this will not get, we will not report on this, and it did not report. It will be ordered for control. Certain issues, certain cases, they have got to work. So one question is, what is implemented is one thing. The other is whether there should be a gag. What is the logic for the gag? And does the gag order mean that it is an infringement of free speech, or is a gag order intended to uphold the dignity of persons in court? That's where we are. We are not on whether or not it's respected, it's not respected, it's implemented. It's a separate question. Should there be a gag order at all? Because if you allow the courts to give out gag orders, then it becomes like when they will give it and when they will not give it, what is the consequence of the gag? So at least the court's dilemma is that if I give out these orders, then I am infringing the right to free speech. The media. The media is, supposedly, the idea is that freedom of the press is one of the most cherished freedoms, and so increasingly we are raising all kinds of questions about it. And the difficulty is how do you curb media without curbing free speech? That's a really difficult question. Who gets to kind of decide on what kind of, and so are we going to expect media channels to publish everything that is the flag is trained? Are they having to censor everything? We all know that's a very terrible idea. So we are still wondering about how exactly that's going to go. Should it be government come to state or should it be like, because I also remember this last year, amendments to the IT Act, which allowed for certain restraint to be imposed on publishing certain material. What was that? You remember what was the amendment? No, it is not equality. It was amendment to the IT Act, which was challenged with the rules of the IT Act, which was challenged with the Bombay High Court. And the Bombay High Court said that these rules were violative of the right to free speech because it required for certain criticism of the state. You know what is that? What was this case? I think it was the Kuala case last year. And the issue was about whether you can be critical of the state, put out information about the state, and if there was information about the state that is in the public media, then there would be a authority that will take up the matter and impose restrictions on the publication of these. Any attempt, however well intentioned, we all understand. I mean, what we're putting out there that you can have hate speech against vulnerable communities. You can have hate speech against women. You can have hate speech against persons accused of particular crimes, which can be very, very harmful to persons who are involved. And we all don't want that there be something done about this. We don't want this freedom to be abused in this particular manner. And all we have right now is this balancing test or the proportionality test to say that, okay, what is the extent of harm and what is the extent of regulation, and the court is somehow trying to come up with some kind of a middle path, which we are believing is not at all adequate. I think that this middle path is not useful. Especially in cases where questions of dignity get involved, there can be no middle path about to what extent can your dignity be taken away. If it is resulting in violations of dignity, then that speech needs to be stopped. There can be no balancing out whether or not that particular community or that group or that individual is suffering certain harm, is not suffering harm. So, what kind of movement in a derogatory manner? Portrayal of the LGBTQ in a derogatory manner. Portrayal of particular religious communities in a derogatory manner. All of you remember that Charlie Hebdo case, right? This was a cartoon that was published in France. It was France where it actually was also depends on the context of the kind of violence that followed the publication of that particular current. And this raised the whole question of free speech about whether newspapers are entitled to portray particular communities in a particular manner, or are these communities overly sensitive and that they are not really allowed for criticism of themselves, because the idea of that is to be able to critique, and everybody living in a society should be open to be criticized. So what is the difference between defamatory or harmful speech and a critique, and what is that fine line that as a society we need to know between speech that takes away the dignity of persons against whom it is being about, and speech that could be a criticism of a particular community? Are we then saying that no community should be criticized at all? And as far as the, like I said, idea of a civil society that is emerging from a democratic space is that we are not friends with each other, but we have rules of coexistence. So the rules of coexistence mean that, okay, I want to do that, you don't tell me, that's it. And we all continue to live with right? That is also not necessarily the best way, because democracy evolves only by an open criticism of certain ideas. So that's the most important. Why does free speech and speech media, the media as an institution becomes so important for us to protect? Is that is an institution that is telling us about the need for a constant critique, which is the way in which that we wouldn't be where we are today if there wasn't this kind of a critique of everything that we had done in the past. So for societies to progress, criticism becomes absolutely critical. Then what is the difference that we want to make between criticism, which should be tolerated by all communities, and speech that is derogatory and speech that is taking away the dignity? And here it doesn't have to be the dignity of the individual at all. In many of these cases, it is dignity of communities as well. Right? So how is this balance to be? So in what we have in constitutional law is balance. But if you want to move beyond balance, what do you do the dignity of? How different would the entire process of coming to a decision be if you based it on the question of dignity? What does dignity bring to the table here? That free speech, reasonable restrictions, what we have tried as here, present danger, proximity, is not adequate to deal with that question. So, for example, what is one way of understanding this question in the context of free speech, for example? One way to understand it is the context of, okay, only those forms of speech which are a critique of the government, which are portraying a view that is not in the majority, portraying a view that is giving you a counter narrative. Only those forms of freedom that are protected and protected speech. But this means that you will have to only talk about ideas which are counter majoritarian in that sense, or which are taking on majority. So, for example, in the Charlie Hebdo case, one of the commentaries that is said about why this is not a free speech question and why the magazine was wrong in publishing that cartoon was that what is happening here is that you're allowing for the dominant community to further marginalize. So if this, I mean, because for ages we have seen cartoons of people in power, right? And the idea of using that kind of imagery against people in power is because it's not possible to do it in any other way. So it becomes a way of, addressing the question of what's the difference between, let's say, a cartoon of any of our leading, any of our prime ministers and presidents, and drawing attention to what they are doing, against drawing attention to something which is already in the public domain, already something which is not so, doesn't receive as much attention. One way in which this has been done is by talking about political speech and saying that, okay, for the rules which are applicable to political speech don't apply to people who are only towing the majority line. So this protection, no prior restraint, this protection of no censorship can only be claimed by people making particular kinds of speech. It can't be claimed by the other. But there's no dignity argument. There's an argument, there's no dignity argument. So if you need to bring a dignity argument in this case, what would it be like? Would it be just that everyone's dignity is the same? But then how do you then say, okay, certain people can be censored, should be criticized? Like you would want the persons in power to be criticized. It's not an idea of free speech, but there should be criticism. So then how do you say, okay, so then because recently we have people who are ultra sensitive, so you can't say this about so and so, you can't say this about X, so you can't say this about Y. If we use the argument that everybody's dignity is the same, possibly can't treat anybody any different. But if you believe that in these cases, inherently there has to be one idea of dignity is previous over the other, how? Understand the question of dignity in the context of speech that is derogatory towards minority community. So that essentially involves the grading of dignities. How do you want to see this? How do you think the dignity question can play out? Because I tell you one case in which I think the Bayer case, we really put it out, say this is not how the dignity question should play out. Because the Bayer case was, somebody was talking about this last previous year. So this is a Russian case about exposing adolescents to the idea of alternative sexuality and gender. Yeah. Anybody want a quick review of the Bayer case?
Yep.
Yeah, so I think there were Russian laws passed which banned the promotion of homosexuality to minors. The European Court of Human Rights held that it is in violation of certain provisions of European Convention on Human Rights. So they held that this is not something which is this is something which is discriminatory towards the minors, and this should not be done.
So the Constitutional Court of Russia said that it upheld the validity of these laws. So this what we get is the European Court, right? That was from the Russian Constitutional Court, they went to the European Court. But what was the appeal against was what the Russian court had held to be an idea that there is a dignity of the community, and especially the idea of how parents want their children to be exposed to particular forms of knowledge. And that deserves protection. And hence the laws were. Okay, so when we are talking about the way dignity gets invoked, and we do see cases that perhaps we think that that is not really the best way in which dignity can get invoked or should be invoked. Because if you're talking about the rights of parents to decide what their children will learn is a recognized right in international law. Because, and this is a, we don't see it so much in India. At one level, we see it. So wherever schools decide to introduce sex education, you have this huge uproar against those schools. This is not this information that you cannot give actually. We don't see it in the same history platform, but of course in other jurisdictions there is very clear, rules about what children will be taught and what they will not be taught in school, including I think theories of evolution are not taught because it goes against the Christian tenet of faith, which is what is created. So you do have a very strong idea of what is it that parents are entitled to decide for their children. And does it violate the CRC? It's a very tricky question to say when and how. And for example, should parents decide that their children not have vaccines? You have this entire, and of course, now what you're saying is whether parents can decide whether their children can have gender altering surgery or not. Because they should be assigned gender at birth if they cannot change until they reach a certain age. So this question of how much do parents decide with reference to knowledge of their children, we know that what we were hearing yesterday also, dignity right of children becomes a very, 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 very difficult question. Because we know the dignity rights include the right to receive. We've said the right to education is a very fundamental right. But at least in the Indian context, when we say education, we mean it in a very instrumental way, right? I mean, you get educated into a job. Education is not really access to knowledge and information that allows you to develop your personality. That is really not at all what we generally refer to when we say the right to education. The idea of why is the right to education a fundamental right is the right to development of your personality in any which way you would choose. By having access to that kind. But how much of this right do our schools actually recognize? How much of this right is something that parents believe that they can restrict and control? Remains a very debatable question. And to what extent syllabus can say something, syllabus should not say something. Even for example, even during COVID, when there were online classes, a lot of parents were flabbergasted at what kind of things their children were exposed to, and they were very, very worried. Parents were getting the education more than their children were. They were very worried, they were very surprised. And why are you learning from this? This is not what we are paying your fees for. So as a certain set of parents are concerned, the idea is that you should get information that gives you learn. With all other information is not really something that is useful to you in these different sets of cases that we're talking about today. The way in which the dignity question plays out can have with certain other things. So one is the dignity question as a standalone idea. The other is where it is so closely connected to some other very fundamental, very important values, is where we start looking at how does dignity intersect with other values. Now, without necessarily getting into this question that there are competing visions of dignity, without getting into this question of dignity versus something else. We are saying how do questions of free speech, how do questions of media regulation, how do questions of information, and how do questions of protection of ideas intersect with the idea of dignity. Does dignity allow us to think about these questions differently as a standalone idea? Or does dignity help us think about these in relation to each other, that is dignity and free speech? Are we saying dignity and free speech because free speech adds something to dignity? Or the other way around, the dignity brings something, the whole free speech question, which is not ordinarily invoked in the context of free speech. So in the Indian context, when you do your balancing, the reasonable restriction, when you're doing any of those grounds mentioned under 19.2, you don't always bring the dignity question there. And if you want to distinguish just like, and here in the context of gender, you can actually add the third dimension, which is the business of discrimination. And one of the few cases which kind of brings everything together for us was Vishaka, where they talked about equality, non-discrimination, dignity, and life, liberty, and access to socioeconomic rights. I mean, the entire theme was lined up in order to make it applicable why there need to be guidelines against sexual harassment. Without segregating that it's okay, there is sexual harassment, and then there is work, and then there is liberty. So how does dignity become something that is an integral part of it? If I'm familiar with why we read 14, 19, 21 together, rather than as standalone ideas of equality and freedom and liberty, we say that somehow by reading them together, they bring something which otherwise is not really evident. And we have also learned that this may not be necessary for all cases. There could be hundreds of cases which can be decided by a simple Article 14. You don't really over. Or just a non-discrimination question. You don't really need to invoke equality. But what are those cases which are best answered by involving all three? And in our context here, by looking at the question of dignity along with equality or along with non-discrimination and liberty in these specific contexts. So you then necessarily have to say that those cases which involve a dignity component. And here the idea of dignity that could be what? What idea of dignity are we talking about? What do you think is the most important idea? Is it a question of autonomy? Because we've talked about very many ideas of dignity. Which idea of dignity is best invoked here? In all of these two cases, could be a case of hurtful speech towards sexual minorities. It could be a way in which there is portrayal of particular persons in the media. It could be a case of access to information because the media serves all three purposes. So in these cases, which idea of dignity do you think be most relevant for us to say that, okay, if you used this idea of dignity, or if you think that no, all of these four cases should be decided on different ideas, you could answer either. Just tell me which, how do you want to decide at least the two cases in front of you? The business of criminalizing particular kinds of speech. When would you want to criminalize particular kinds of speech? How would you distinguish between speech against one community and against the other? If you have to make any kind of a dignity argument, then what kind of dignity argument would be that? Let's just list off the various ideas of dignity you've talked about so far. What are the various ideas of dignity we discussed?
The basic ideology behind that, the media trial, according to me, that is the most appropriate, which can infringe the individual dignity, because before like following the judgment and anything procedure happen, media itself claims you a convict, like person who decided like the judgment on the basis of people without even like hearing my voice, because the face is clear, so it is infringing my own personal dignity also, because everything we justified that the judgment is in favor also, but society will not accept me, because they will every day on a basis I have to suffer that kind of like what we say humiliation according to society, because the any institution, if I'll like as a teenager, if I'll commit and go into media trial and something happened, as a teenager or as a student, I'll suffer this situation in college also, because people will mock me and they say things. So as an individual, that is my stake, that it will infringe my dignity.
But then it doesn't only have to be a media trial, no? That virtually means that, and of course, we do have prohibition against minors being photographed. That's the reason why we have those prohibitions against women's names being disclosed or minor faces being
Not disclosed in the rape case, but
Right.
specifically to
So that's
cases.
not media trial case. That's literally just any information on media you would want to. You have a reason why you are prohibiting certain information from being available. But that automatically makes other people more susceptible, right? So if you're a middle-aged man who has been accused of a crime,
Because nowadays we are always on social media, it is very easy and accessible that if fake news also is like ongoing on social media, instead of accusing on like authentic platforms. So it is very easy nowadays to
so one way to say that we can't control it anyway.
yeah. Okay.
Nothing is possible. So can we just say that okay,
Because
this
when
is a
we
useless project because we're not going to be able to stop it.
Yes, ma'am. Because when we have provisions related to IT Act also, it also like states that if something is ongoing on social media, it should be like what we say within the limited time period, it should be like prohibited or something.
yeah.
But still, it is going on here.
I know. And I'm watching. People have like particular cameras shows which need to be taken down.
Yes.
So we know that this algorithm will work. It's just that it works for some and not for the others. Particular kind of information is still susceptible to be removed. So there is a solution that does not have a standard because the chance of misuse is far higher than the chance of it actually being used. So is that aspect going to be relevant or can we actually talk about it? I mean, it doesn't have to be something very big. It can be something very day-to-day all the subactors, right? Whether in employment places or education places. Fine, if you remove the children tag. You still say students, that students can be, you can have a slightly higher rate, right? So what kind of information can you disclose? Should you disclose about it? So it doesn't have to be media. It can be something that all of us at different point of time have to deal with when you're faced with a set of people who believe that this is outraging their dignity. Then how should we respond to it? Should we say that okay, humiliation, for example, is it an individual experience of whether I feel humiliated or not? Because people can feel humiliated for many things, which anybody else with gender. I mean, if you have your decency, morality, context, there are a lot of people who is not humiliated. And this happens in the case of sexual harassment as well. I mean, you believe that there are certain experiences, certain people who think that it is harassment. And if you talk about gender as a standard, then there's that. So what is going to go with? If you make it so much of an individual choice, then you can have a whole range of very privileged people who are feeling very outraged because somebody actually managed to say something against. So one hand you will have that. And on the other hand, if you say that it's the same dignity, then you're actually not able to address the really critical questions, which are reflective of whether it is misogyny, whether it's prejudice, whether it's bigotry. How are we going to address these questions without saying, okay, the right is available to everyone? How do we talk about particular categories of cases? Is it on the question of relation or on the question of information? How will dignity become something that throws the light on the issue, which otherwise gets kind of driven by other issues? I mean, if you talk about whether it's the press freedom, it all becomes about freedom of speech and expression. The dignity argument is not central there. Or if you take the finance issue, then you have a very different kind of idea that is there. Dignity is not really featuring in these cases. So one of the ways in which, and the idea of using dignity as a very key concept is in the context of using dignity with stigma and humiliation and understanding of the position of particular groups in society, where speech against them is far more harmful, not just hurtful. So that distinction that this court is trying to draw between being hurt by something somebody has said or something turning into a harm. So the question particularly of vulnerable groups is that when you target particular groups, then this becomes far worse than speech that is directed toward others. So, for example, in the context of violence against women, when views such as, I mean, after the Nirmaya case, you have people voicing views, of course, women should stay at home, women should wear particular clothes, women should do this kind of views, which kind of providing justification to act of violence. Right? And there was clear connection that is being drawn between views which are held by people in society per se, which leads to increased violence. And the harm question that we are then able to come to there is with reference to how the question of the dignity of the individual as well as particular groups with reference to the kind of portrayal in the media becomes a very critical part of their experience of a dignified existence. If you're portraying people of particular religions and communities in a way that kind of creates an impression in society around you, makes it difficult for them to navigate and negotiate and live on an equal footing and equal dignity with the others. That speech definitely is to be curtailed both from the point of view of free speech as well as the question of dignity. Dignity brings an angle to that discourse which otherwise perhaps can get framed in a very different way. So pitfalls is what the Russian constitutional code is. Of course, there can be invocation of dignity in a particular way that is reinforcing the fact, reinforcing prejudices. So one needs to be very careful about dignity necessarily being something which cannot reinforce bias, which cannot reinforce existing social prejudice. That has to be a very important idea of the way in which dignity gets used, because we all know of the criminal defamation cases where in India, where dignity was used against this person, against newspapers' right to publish about people in positions of power and authority, by saying that defamation cannot be removed from the books because there will be the right to dignity of people who are in positions of power, which needs to be protected by. You will see invocations of dignity like that, merely pointing out to you all of dignity just because it's used doesn't automatically mean it is the right way which you would want dignity to be understood. To be a little cautious here. Any questions on this? Any comments?
So, ma'am, while working on this whole project of how the media trials impact the dignity of particular accused in a case, I came across various instances where we need to balance between what kind of information is being released into the media for the information of the public, vis-a-vis how that impacts the dignity of the accused in question. So I think in my analysis, I looked at two instances. One was the infamous Arushi Talwar case,
Yeah.
wherein the 13-year-old child was literally slut shamed
Yeah.
because her chats were released by the police officials themselves, and then justice was sought against for her against her parents.
Yeah.
Her parents were charged and they were absolved after many years.
Yeah.
This was one instance where information was released by officials in the garb of public information
Yes.
being released out to the media. The second instance is a very recent one, wherein a girl named Muskan was accused of murdering her own husband with her partner. Now, she was in custody, she was in jail, but she was found, she was pregnant, and this information was not even made through an official report. A jail official got it through verbal communication and he released it to the media. And the media then got into a debate of whose child it was. Now, neither the court addressed this question, nor it was criticized that how can something which should have given maybe a kinder treatment to the accused became full point of vilifying her individuality, of her right to be with somebody or whosoever's child it was. So I think in my analysis, I got a bit confused about how the court then should seek to strike the balance of what should be released into the public as part of our right to know the information. Vis-a-vis, how should we then balance it with the dignity of the accused?
So I think here, as you were saying, there is such a, apart from free speech, there is a question of privacy. And so what would be private information which can't be revealed, which shouldn't be revealed by persons, they should know, I mean, at least police officials and jail officials should know that they have a duty to respect the privacy of persons in their custody. And where would the privacy question intersect with the dignity question? Because usually we say privacy is located in dignity. But the dignity question, the privacy question can actually also, it's dignity and privacy. It doesn't have to be one, I mean, they're not necessarily always just one consolidated concept. So there is the dignity concept. And in particular ways, in this case, for example, the person's right to be, in whether it's the Arushi case or in the second case, the dignity question is of intrinsic value, which is that you can't talk about people in a particular way, especially in one case, the person is no longer alive. So that's this whole business of the dignity of the dead, right? Without necessarily getting into the reputation of the dead. So there again, we need to draw those lines carefully between what is reputation and what is dignity. Yeah. So because many a times they're just very conflating. I mean, you really don't know whether you're talking about the right to be seen in a good light by everybody versus the right that, every person should be considered in a way that you don't talk about them in a particular way. So this whole business of, for example, why there is a general ethic of not talking about the dead, because they will not have the opportunity to say anything or defend themselves. So that line that we want to draw. But there again, you'll have a problem, let's say, of historical figures, right? We had this whole free speech question that historical figures should not be defamed. But historical figures who had a public, so this whole business of privacy becomes very important. What are my questions of privacy and what are my public views which can be criticized even after my death? There should be open criticism of historical figures also, and nobody should say that they become. So those lines become important to draw, and then dignity to be separated from privacy also might be a very important and interesting way of answering this question without kind of conflating everything to be the same. So what are the ideas of dignity of intrinsic worth, ideas of dignity of, where does the privacy right become different from a dignity right? And how much information should be in public domain about people and how much should not be? How do you preserve the dignity of the dead while keeping certain parts of their persona open? I think would be an interesting exercise to do. Anybody else? Further comments, questions? So even in your project, that you're looking at this whole, so social media is invasion in class. Then again, what is the privacy question or the dignity question? You're able to articulate the dignity in Parliament. We stop, take a 5-minute break and come on.